Thank you so much, everyone, for joining us. We are going to get started in about 4 minutes.
Josh, can we just test your audio super quick?
How does this sound, Joe?
Good.
Good, thanks.
All right, it looks like we are right at 3:30. Hello, everyone. My name is Elizabeth Brady. I use she, her, hers pronouns, and I'm so excited to welcome everyone to our next and final session of Virtual SUNY Spectrum 2020. Before I hand it over to Beth Garvey for our official convening of the session, I do have a few things that I wanted to share with folks. First, closed captioning is available. You can select that option at the bottom of your screen. And second, I wanted to sincerely thank a few folks who have been instrumental to the execution of today. Thank you sincerely to my team, the entire SUNY's Got Your Back team, who have really been the backbone of this conference. Morgan Clifford, who has been supporting speakers and logistics and me during the sessions, Roma Shaw and Philip Potter, who have been our tech support folks, Delcy, who has been helping to engage folks on social and in the workplace group, and Erin Hogan and Joelle Carroll as well. Thank you so much to the SUNY Student Conduct Institute for sponsoring this conference. Thank you to the SUNY Center for Professional Development, who have offered unparalleled support and information and just kindness in general as we navigated this new version of a conference. Thank you to our speakers. And thank you to all of you once again for taking a chance and joining us for this conference virtually. Something that I myself wasn't sure about, but moved forward with blind confidence that folks would show up and participate, and you all did. And thank you for your continued commitment to this work. I started this week by stating something that literally no one needed to be reminded of. This work is hard, and recent events have only created new challenges and intensified old ones. In spite of this, every single person in attendance at this conference has continued onward in your relentless pursuit of supporting students and creating a safer, more just world. I know that our panel is eager to get started, but I'm going to invoke my director's privilege and take up a bit more time and to both thank and welcome one more person, and that is Beth Garvey, who serves as special counsel and senior advisor to Governor Cuomo. Beth has been a true champion of this conference and the work that my office does, and personally a role model to me. I'm so grateful that you're here, Beth, and delighted to invite you up to the virtual stage to formally convene today's session.
Thank you. Thank you so much. It's really, I was saying earlier, it's really just a pleasure to be here. This was something that I was looking forward to all week. My name is Beth Garvey. I work for Governor Andrew Cuomo as his special counsel and senior advisor. My pronouns are she, her, and hers. And I have been a staunch supporter of this conference since 2018, the very first conference when we welcomed 620 people to Albany to start doing this important work. And, you know, it was really thanks to Joe Storch's vision and leadership that we got this off the ground, working with Elizabeth Brady and the rest of the team with SUNY's Got Your Back. And I couldn't have been more proud to be part of that. This year, I think we will have welcomed over 1,600 people to this virtual version of the conference. And I have to say, I really hope that it's not because you didn't have to travel to Albany, New York to attend, because Albany is beautiful, especially this time of year. So when we get back to doing these conferences in person, I hope you will all come and do it again in person, because I know that there are limitations to this type of virtual collaboration. But I'm glad that so many people were able to be here and to interact because this work is so important. And when we look at the needs, even now, to keep fighting this fight is just really such an important thing to do. Governor Cuomo, you know, certainly believes that this fight is very important. We have been on the cutting edge of LGBTQI plus rights since he came into office. And so I have worked with the governor in many different roles, really. Most recently, prior to this, as SUNY General Counsel, where we were in charge of SUNY's Got Your Back, Spark, the Student Conduct Institute to implement the groundbreaking Enough is Enough law. But really, New York has been on the vanguard of this work from the beginning. And we're really just very happy to be here. One thing that I do want to tout is the fact that we just this week opened the Marsha P. Johnson State Park. We renamed the East River Park for the first time ever in the state for a transgender woman of color. And I think that, 2020 has been just such a challenging year in so many ways, but it really has crystallized, I think, overall, our commitment to the things that are truly important. Having these shelter in place orders, having all of these other challenges, seeing the tension between police and communities of color across the nation that were spurred by the George Floyd killing. These are things that, really I've been inspired and humbled by New Yorkers and this country's willingness to do the hard work and ask the hard questions. And I know that the work that this conference is doing is part of that important and challenging, really, effort to get to clarity, to get to equality, to get to a place where every person feels equal to every other person. And so I'm really just very excited to be here, and I'm really pleased to see that partnership is continuing with so many organizations, and that SUNY is, again, as former general counsel, on the forefront of that. So, we have to go beyond just the work that I do here in the state capitol. We have to go beyond passing laws. We have to go beyond, naming parks, even as much as I know the representation is important. And we have to really do that hard work. I've seen firsthand the great work that can come out of this conference. And I know that you're going to be bringing these ideas back to your campuses and your agencies, and that's really where the rubber meets the road. So as we continue to address these challenges, I know that you are going to hear from a great panel of experts who are going to help us work through the major changes that have kept coming, even as, we've been sort of New York on pause since March. The hits keep on coming. So I'm going to get this panel to work. I'm going to turn it over to Joe Storch. And again, you have my sincere wishes for a wonderful and productive 9-on-9 session here, and that hopefully this is the capstone on the work that you've been doing this week. So Joe, turn it over to you.
Thank you so much, Beth. And it's hard to say how much we appreciate the support we've had from you when you were at SUNY and since in the governor's office. And it's what allows us to do this work. And we're so appreciative. And thanks also to my great colleague, Elizabeth Brady, who does all the real work to put this together. And everybody knows just what tremendous work she does, and the whole SUNY's Got Your Back team and the whole Student Conduct Institute team. What an absolute privilege. I think Beth would agree with me. The only thing I'm really good at is HR and hiring. And so we have an incredible team, and we have here an incredible panel. So I'm going to introduce them very briefly. You can see their full bios on the Spectrum website in the order that they appear on my computer. We have a ton of content to get through. This is a 9-hour panel that we're going to do in about 90 minutes. So Melissa Carleton is a shareholder at Bricker and Eckler. Shiwali Patel is senior counsel at the NWLC. Rodney Pepe-Souvenir is the university-wide Title IX coordinator for the City University of New York. Paige Duggins Clay is an associate attorney at Husch Roberts. Am I saying it right? Husch Roberts, right?
Husch Blackwell.
Oh, Husch Blackwell. Sorry, I was trying to say the Husch part
Oh,
right.
I'm happy to present the merger with Scott Roberts' firm as well.
Right, indeed. We'll wait for that. Kate Nash, who's a partner at Tueth, Keeney, Cooper, and a bunch of other names. Scott Robert, who is a managing partner at Hirsch Roberts Weinstein. Jody Shipper, who is the managing director at Grand River Solutions. Natasha Baker, who is the founder of the Novus law firm. Josh Richards, who is a partner at Saul, Ewing, Ernst, and a bunch of other additional names. And I get to moderate. I'm Joe Storch. I'm an associate counsel here at SUNY. I use he and him, and let's just dive right into it. In the midst of the pandemic, many of us were watching the Supreme Court and waiting as it considered three monumental cases on Title VII. They were consolidated under the name Bostock versus Clayton County. Justice Kennedy, who had written some seminal opinions in Lawrence, Windsor, Obergefell, and other cases, was retired. We didn't know what we are going to find out, and we got an opinion that I think surprised many of us. Let's start with a brief factual summary of the three cases that the court was considering: Bostock, Zarda, and Stevens, and I will turn it over to Melissa Carleton. Melissa?
Great. So yeah, we had three cases that came out of three different federal circuit courts of appeals. So we have the Gerald Bostock case. This was a case where he worked for Clayton County, Georgia, and was a child welfare advocate. And under his leadership, they won a lot of awards for the county work. So he is there for about 10 years, and then he decides to join a gay recreational softball league. And right after that happens, there's a meeting where an influential community member makes an kind of disparaging comment to his boss that, hey, he's in this league and he's gay. A couple days later, Gerald gets fired. So that was case number one out of the 11th Circuit. It was decided that the law did not prohibit firing employees for their sexual orientation. So that was case number one. Case number two was Donald Zarda. Donald Zarda worked for a skydiving company in New York. He mentioned that he was gay, and he got fired within days of that mentioning to his employer. And this is after he had worked there for several years. So Second Circuit considers it and says Title VII does prohibit discrimination on sexual orientation, which put it in direct contradiction to the 11th Circuit case that had been issued in Bostock. The third case is from where I am in Columbus, Ohio, 6th Circuit, which governs parts of the Midwest. Amy Stevens was working for a funeral home in Michigan, and she was getting ready to leave for a vacation. And so after having gone through treatment for several years for gender dysphoria, she wrote a letter to her employer saying, I'm getting ready to go on vacation. When I come back, I am going to be living and working full-time as a woman. The funeral home sent her a letter and said, thanks, but no thanks, this isn't going to work out, and terminated her employment. She had been working there for 6 years at that point. So these are the three cases that come up. 6th Circuit in that case said Title VII barred discrimination on the basis of transgender status. And when they all get appealed to the US Supreme Court, they get added together into one, and that's how we get to just Bostock.
Thanks, Melissa. And Kate, I'm going to turn to you. So Melissa has teed it up for you. We know what the court was considering. How did it rule on the question of whether Title VII's prohibition of discrimination on the basis of sex, as detailed in, or as denoted in the statute, covers sexual orientation and gender identity?
Sure, and it's a pretty easy, straightforward question to answer. The way that the court approaches it, Supreme Court cases are often interesting to read because the majority makes it sound like there's no other conclusion that could be reached. And then you read a dissent, which is also written in a way that sort of assumes there is no other decision that could be reached. And that's true in this case as well. And this is a pretty quick analysis. So I'll just say this is one of those cases that I think for many of us did not come out the way that we expected, as Joe suggested. This is one of those cases where I will always remember where I was when I found out about the opinion. I was in a staff meeting where I'm acting general counsel, and I saw it. I was on Skype and I started crying, and I broke into the staff meeting and said, I have to share this with everyone, and everyone started clapping. So it was a really exciting time. So a pretty simple analysis here. So what the court says in a 6-3 opinion is that we just look at the plain language here, and what Title VII prohibits is discrimination against any individual because of, and the statute says, the individual's race, color, religion, sex, or national origin. And what the question they were deciding was, does sex include sexual orientation and gender identity? And in a 6-3 opinion, the Supreme Court said, yes, it does. We just look at the plain language of the statute, and you cannot consider sexual orientation or gender identity without thinking about sex. And because it is in some way related to sex, it is prohibited for employers to use that as a basis for discrimination. And this, I think there was a lot of surprise by many of us because the earlier opinions had been 5-4 opinions that were decided by Justice Kennedy as a swing vote. He had retired, as Joe mentioned, and this opinion is authored by a Trump appointee, Justice Storch. So it was a surprise, and but a pretty straightforward reading that just says yes, because of sex includes gender identity and sexual orientation.
And so interesting that it was written from the conservative viewpoint of originalism and original interpretation of the statute. And so very interesting to read the opinion and the dissents. Rodney, some thoughts on the Bostock et al. Opinion?
I think it was just so interesting how Gorsuch really tried to align Title VII with the whole idea of protecting the rights of someone who's gay. And I think the best line in his opinion was, but the limits of the drafter's imagination supply no reason to ignore the law's demands. I think that was the best line of the opinion, because it caused us to have to think outside the box and to be more creative when we are applying the law. And had we not had that kind of interpretation, who knows where the decision would have gone. But I thought it was just so smart of him to put that in there.
Yeah, it was a very elegantly written opinion. Natasha, your thoughts?
Yeah, I was just gonna say, I like Kate, I remember where I was. I sat down with a glass of wine to read it, and that opinion is lit. If you haven't read it, it's a really fun read. It's really affirming. And the fear was that they're interpreting an anti-discrimination law that was passed back in 1964. So the fear was going to be that they were going to use the conception of the definition of sex from that time. And so to read Gorsuch, as Rodney said, to go through it, it's just a really fun thing to do. So, I don't often say reading Supreme Court decisions are fun, but I would do that this weekend if you haven't.
I live to have Natasha declare legal opinions as lit. That's the best
It was. I'm shocked.
For sure. Shiwali.
Yes, and I just want to add that, as an advocacy organization at the National Women's Law Center, we've been really kind of eager to see how the federal government will be responding to this decision. And what we did in July with other advocacy organizations is we wrote 2 letters to the federal government. We wrote one to DOJ urging them to begin full coordination of implementing this decision, to instruct other federal agencies to withdraw guidance that's inconsistent with it. And we also joined a letter earlier this month with other advocacy organizations to OCR, so the Department of Education's Office for Civil Rights, asking them that they take immediate steps to protect LGBTQ students and educators. So, for us, I think we're very interested to see what would happen in terms of enforcement in other areas of sex discrimination.
And I think, Shiwali, you were probably the first to discover yesterday what we all discovered. I gave you a hat tip on social media because I saw it with you first, that the OCR didn't exactly do that. Instead, they basically just did a going out of business sale on every piece of guidance that they've issued since I was a teenager.
Sorry, I was on mute. Yes, exactly. And they didn't even, the announcement wasn't very public. I think it was quite notable that the 2001 sexual harassment guidance and the 2017 Q&A guidance were part of that list. And a couple of days ago, they had issued a notice that they were also rescinding the Title IX coordinator guidance, gender equity and career technical education guidance, among a list of other types of guidance throughout the department.
So I think that's a perfect segue to shift to Title IX. The Supreme Court in a number of cases has applied the analysis of Title VII, what we just were talking about in Bostock, to Title IX cases. And a couple of major case lines we're going to talk about is bathrooms corresponding to gender identity in schools, and participation in athletics. I want to start with some of the bathroom cases. We've seen a line of these cases in a number of circuits, including some news this week, and we have seen Circuit Court of Appeals that, to my reading, have all ruled exactly the same way. I want to talk briefly about the facts of some of the recent cases, Adams and Grimm, as well as some other cases, and what some courts have found to date. So let me turn it over first to Rodney to give us a summary of what we're seeing out of the courts.
Sure. So in the Grimm case, you have this young man who was in high school, transgender male. He had been using the boys' bathroom for several weeks, and then it was discovered that, you know, he was a transgender male, and there was some controversy about him using it. The board quickly tries to come up with some kind of rules and regulations as to which bathroom he could use, which basically stigmatized him because he had to use a bathroom in the nurse's office or some other single stall bathroom. I mean, it just really put him in a bad space. He then pursued litigation, and it almost got to the Supreme Court and then was pulled back again to the Fourth Circuit. And we just have this recent, 2 days ago, actually, as you said, hot off the presses decision, that they found that it was a violation of Title IX. Although he's no longer in the school and it would have been a moot issue, but he was filing under a small monetary request of monies. And so that was what helped keep the case going. So we have this great decision, and they talk in the decision about Article 7 and the fact that the but for, you know, it is discrimination based on sex. And then we have the previous case, the Adams case from August 7th, where the decision was basically the same. Again, it was a young transgender male using the bathroom, not able to use the bathrooms anymore because they came up with these rules and regulations, having to deal with that stigma. And through his mother was able to file his brief along with several other agencies who supported him. And again, they came up with the same theory of this being a violation based on sex, that but for his sex. And this what's so troubling is the fact that they're relying on whatever birth a sex you were assigned, what the sex you were assigned at birth was what made the decision as to where you could go, which was just so unfair. And I remember in one of the decisions where they talk about the fact that it almost is discriminatory against somebody who is transitioning into transgender, because if you happen to have come in and had all your reassignments done and you're a transgender male, you could use the bathroom and there'd be no problem. But because in these instances, they had their records still with whatever they were assigned at birth, it made it a whole different story. So I'm very happy with the results coming out of both the 11th Circuit and the 4th Circuit on these cases.
Excellent. Thanks, Rodney. Kate, your thoughts?
Yeah, I think it's interesting, the timing of all of this. I know 2020 is the year of the dumpster fire, but I have to say personally, I'm very grateful for the timing of the way this came out, after Bostock, because whenever, as Rodney mentioned, Grimm was on a path to Supreme Court earlier. And at that time, there was a lot of discussion about would sex under Title IX be considered biological sex? What would that look like? And I think then that opinion would have had, precedential or at least some value in terms of interpreting Title VII. So while it's been a journey to get here, I feel very gratified by how we got here. And I'm grateful now that we have the Fourth Circuit opinion that is following on the heels of Bostock. And it has not, while I said in my remarks that we sort of, you read Supreme Court opinions and they read as though there's no other possible opinion, the outcome of the Title IX cases was very much in debate over the many years we've all been watching this issue. And there has been a lot of litigation around privacy rights of people that were opposed to rights for transgender students, utilizing Title IX as a vehicle for that. So I just want to take a moment and say, there are a few bright moments of 2020, and this is one of them. And I think the Graham opinion, this Fourth Circuit opinion, is something to celebrate, and the timing of it is something to celebrate.
Thanks, Kate. And, you know, as Natasha said earlier about Bostock being lit, the Fourth Circuit opinion is a real read, including some cultural touchstones. I noted just a few pages in, nevertheless, he persevered, you know, and some really, really wonderful language. I recommend to everyone to go to the end, and there's something, I'm going to paraphrase it, but it's something like, the best part for a federal court is when they could advance civil rights, and that's what we're doing here, affirmed, and they say it much better than I said. Jody, the courts didn't just look at Title IX, they also looked at equal protection. Can you give us a beat on that? Oh, and you're muted.
Of course.
The most common phrase of 2020. I think you're on mute.
That is the phrase. Thank you. I'll get that on a t-shirt shortly. But, you know, one of the things to remember about Gavin is that, yes, he had graduated, but he, in order to go to college, also is going to need his transcripts, high school transcripts, to give to the college. And those continue to identify him conforming with the birth certificate he was given at birth, and not with the corrected birth certificate that he had gone to court. It was verified by the clerk that his new birth certificate now identifies him as male. And there was this ongoing refusal by the board to even correct the records. And so there's both the treatment at the school and then this refusal to correct the record. And so we have both going on. So equal protection, really quickly, is that the state, it's a public school, can't deny equal protection to anyone. And the part of the question for the court is this a decision based on sex or sex discrimination, such that some kind of higher scrutiny, higher level of scrutiny is going to be given to the school's decision that he cannot use the boys' restroom and has to use this other stigmatizing bathroom? And they said, yes, this is a decision based on sex. It's a form of sex discrimination. And so the court applied this heightened form of scrutiny. And in applying that, the school's purported reason for wanting to have this differential use of bathrooms was related, the school related it to what they called their interest in protecting student privacy. And to continue the theme of the decision being lit, the court really goes through and blasts the school and the school district, noting that he used that bathroom for weeks without problem. And in fact, the bathrooms became safer. They added strips and privacy partitions, and yet couldn't be allowed in. And then there was this whole myth, if you let boys in, you know, then anyone can dress up like a girl and go into the girls' bathroom. And so the court also really, I thought, handily dispensed with that. So in the end, they said that there is no way that the school could meet, that their policy, this idea, was not related to what they called their important interest in protecting students' privacy. And they couldn't withstand the scrutiny level that the court was going to apply. And they really did blast the school. There's also a great line in there about the board really ignored the reality of how a transgender child would use a bathroom, and talks about what they do is they go in and they close the door and do what they need to do and leave and wash their hands and exit the bathroom, not a privacy issue. So there's a lot of good stuff in there that was written, I think, really in a really respectful and lit way, to use Natasha's phrase.
Thanks, Jody. Natasha and Paige, you know, the Congress and in some ways the Supreme Court makes or interprets law for the land, but we have individual federal circuit courts who make law for a number of states, and we have some states that weigh in on some of these issues, sometimes in ways that we like, often in ways that we don't. Turning first to Natasha to provide us some thoughts.
Yeah, I guess this feels like where we were probably a decade ago before the seminal decision by the Supreme Court in the marriage cases. I mean, it's a patchwork of civil rights right now. And so just to kind of put a fine point on on what we've all been talking about. Now we know conclusively under Title VII, under the Bostock decision, discrimination on the basis of sex includes gender identity, gender expression, and sexual orientation. We now know that that has been applied under Title IX. And remember, Title IX is not just educational institutions, it's recipients of federal funds. So it's got a broader application than simply just employment. And we know that in the 11th Circuit, in the Harris case, in the Adams case that Rodney was describing, that they've applied a parallel interpretation of discrimination on the basis of sex under Title IX as they did in Bostock. So we know now that what's going to happen in the 11th Circuit, but that's only Alabama, Florida, and Georgia. So then we look to the 4th Circuit, where the Gavin Grimm case is coming out of, again, applying Title IX, so broader than just employment. And thus we know that in Maryland, North Carolina, South Carolina, and Virginia, that the interpretation of Title IX is going to include the same definition as it did under Bostock. So we're starting to see this. And then what we see from there for circuit courts that haven't ruled is the application of state law. And I think Paige and I were going to talk about this. I'm in California. It's been covered for a long time. Paige is in Texas, and she was going to talk about some of the opposite direction that state is going. But it does feel like pre-marriage cases where it's a patchwork of civil rights. And then I think later on in the session in the program, we're going to talk about some of the other Supreme Court decisions that are chipping away at some of these decisions through the Religious Freedom Restoration Act. So Paige, I don't know if you want to say what's happening now in Texas.
Yeah, happy to chip in here. And Texas is great on a lot of things. My favorite food, chicken fried steak, blue bonnets, great beaches, of which I actually am. This is not a real beach, but I actually am at a beach this week, and it's great. Texas, unfortunately, has not been great on many of our country's civil rights issues, including gender and sexual orientation status protection. And so I just wanted to chip in here to say, for those of us who are not covered by those great decisions out of the 4th and other circuits, in the 5th Circuit, our case law says that Title IX and Title VII, that Title IX does not encompass any sort of sexual orientation or gender identity status. And so, of course, in the Lone Star State, at the last legislative session we had about a year and a half ago, there were very vigorous efforts by conservatives to introduce state legislation that would actually totally contravene the ruling handed down in Mr. Grimm's case. And so we were delighted. There was a lot of really strong advocacy that frankly crushed that attempt to codify what Texas has called the bathroom bill, and it would have limited your ability to use a bathroom to your sex assigned at birth. That did not go into effect. Texas's legislative session starts again January 1st, 2021. We have yet to see if they'll refile that legislation. I know there are other states, particularly in the South, that have looked at that as a model and are considering it. So we're hopeful that, especially with great precedent like Bostock and the other circuit decisions, those efforts will now be even weaker than they were last time around, but we're still fighting them down here in the Lone Star State.
Excellent. Thanks, Paige and Natasha. Shiwali, your thoughts, especially as you look forward into the future.
Yeah, so I just wanted to chime in and kind of echo some of what's been said about how critical it was for the courts to reject, the concerns cited by the opposition about, privacy and safety concerns of cisgender women and girls, which is just unfounded and based on this harmful and broken logic that's been used to keep women out of some jobs historically and people of color out of public facilities. And the National Women's Law Center actually has submitted an amicus brief in these cases, reiterating those arguments and also explaining why, excluding transgender students from bathrooms that correspond with their gender identities actually can cause more physical and emotional harm to transgender students who are more likely to suffer from bullying and harassment. And so, it was really great to see the decision to finally to have a resolution in the Gavin Grimm case. And I'm really looking forward to seeing, what happens from there.
And Melissa, a beat on Ohio?
Yeah, so Ohio, you might think I'm going to say is like Texas, but I'm not. Ohio is an interesting place because we have a case out of the Southern District of Ohio, which covers Columbus and Cincinnati and a good portion of the state, where it is your constitutional right. Under the US Constitution, we have an equal protection decision allowing a student in a K-12 institution to use the bathroom that corresponded to their gender identity. So, right now we're talking about things based on statutory language, Title VII and Title IX, and all of that can change with the switch of a congressional challenge, right? All they have to do is rewrite the law. I think the next frontier is really going to be the constitutional protections.
Excellent. Another line of cases that a lot of us are tracking and thinking through have to do with participation in athletics. Scott, I'm going to ask you to look further west towards Idaho. We have a law passed in Idaho. We have litigation in Connecticut and challenges elsewhere. Scott, if you could start for us by summarizing the law passed in Idaho, as well as the decision in Hecox versus Little that just came out, I think maybe 8-10 days ago, and then I'll turn to Shiwali for some comments. So let's start with Scott.
Sure. And the Connecticut actions and the Idaho actions go very neatly together. In the beginning of this pandemic, oddly, Idaho saw fit to pass a law that categorically excludes transgender women from participating on women's sports teams. They are the first and only state to institute this kind of bar. And the bill's sponsor said that the reason that they were doing this is because the participation of transgender women posed a threat. Remarkably, even though schools were closed, the governor went forward and signed this bill, which contradicts both NCAA and International Olympic Committee policies. One of the most disturbing aspects of the Idaho law is that it includes what's known as a dispute process, whereby evidently anybody and everybody can challenge the sex of any female athlete, whether or not they're transgender. After which, upon this challenge being raised, that athlete then has to go through a sex verification process to verify their biological sex. Equally disturbingly, it affords a private right of action to any student who contends that they were deprived of athletic opportunity due to the participation of a transgender athlete. In many respects, that's the kind of argument that is raised and continues to be raised in the Connecticut action. Now, the court here recognized that the case presented a number of complex issues relating to the rights of student athletes, the differences between the sexes, the right to medical privacy and the like. But at the end of the day, I think the Idaho court in the District of Idaho was tremendously unimpressed by the government's arguments. Jody mentioned a moment ago the test for heightened scrutiny. And in order to pass heightened scrutiny for a law, you have to have what are known as important governmental objectives, and the law has to actually be related to attaining those objectives. Well, as is typically the case in cases like this, the objectives always sound fantastic, protecting privacy, assuring people are fine. And the government certainly had a bunch of nice sounding objectives here, promoting sex equality and providing opportunities for female athletes, the ability to get scholarships, all of which sounded really good. And the plaintiffs even agreed, hey, those are really laudable goals here, but this law doesn't serve them. And the court very easily agreed. They said that they just didn't see that the law was serving or solving any sort of actual problem. And went so far as to say that the plaintiffs had presented very compelling evidence that equality in sports isn't jeopardized by allowing transgender women to compete. There was some, to use Natasha's phrase, some very lit language in this decision as well. And I just want to read it. It said that the bill sponsors arguments that the plaintiff and other transgender women are not excluded from school sports because they can simply play on the men's team is analogous to claiming that homosexual individuals are not prevented from marrying under statutes preventing same-sex marriages because lesbians and gays could just marry someone of the different sex. It was, again, a really kind of in-your-face punch to this argument being raised by the government. So they conclude by essentially saying they're going to enter an injunction against this law, which is a court order barring it from taking effect, because they felt that the state hadn't identified any legitimate interest served by that act. And I thought it was, again, a very well-reasoned and very matter-of-fact opinion. I mean, the bulk of this 87-page opinion is addressed to determining who can participate in this litigation, but the analysis is done in a crisp 25 pages. So again, the points being raised here and the legal issues addressed are done in a really clear and compelling fashion.
Thanks, Scott. Shiwali, Scott has really kind of teed up the issue. What are your thoughts?
So I just had a few thoughts about the OCR letter from the Department of Education's Office for Civil Rights with respect to what happened in Connecticut. You know, where here in that case, you know, there was a state policy that was doing the right thing, which was supporting inclusion and equity in athletics for all students. And through an enforcement action after receiving a complaint filed on behalf of high school students and their parents. And, you know, they were represented by an organization, the Alliance Defending Freedom, which is known as a far-right extremist organization. They've been labeled as a hate group that's been targeting LGBTQ individuals. The department had, you know, issued a letter essentially kind of stating that the law that was really about equity inclusion was, you know, violating Title IX, which really just turns Title IX on its head, and, you know, wrongly using the statute, this anti-discrimination law, claiming that doesn't apply to a subset of girls, right? Because, you know, a subset of girls who are transgender, which ultimately will harm all students, and, you know, really relies on this false and harmful belief that trans girls are not really girls and are taking away participation slots from cisgender girls, and that transgender girls have an unfair competitive advantage over cisgender girls, both of which aren't true. And so, you know, our organization, along with other women's rights, gender justice organizations, have kind of written a letter to that effect of supporting trans inclusion in sports. And, you know, we've been really disappointed in many actions by this OCR, including this one, the Connecticut case.
Just to follow up on Shiwali's point about the OCR letter, it is, I can't think of another word to use other than it's ugly. That the Office of Civil Rights is coming out and opining that allowing transgender high school athletes to participate would violate the Title IX rights of female athletes. If there's any heartening moment to this, it's that in the Hecox case, which is the Idaho case, the court explicitly said that OCR letter, first of all, they state it's a statement of, it's not a statement of OCR policy, but more importantly, they state it's of questionable validity, given the Supreme Court's recent holding in Boston, which I at least found pleasing. Coming out of a conservative jurisdiction such as Idaho, that was actually nice to see. I agree also with Shiwali that the Connecticut case has been pursued in a manner that, again, I think the word ugly applies. They have, you know, sought an injunction here precluding the policy of allowing participation by transgender athletes. And although there is no need for an injunction because schools are not open, there has been an aggressive pursuit of the effort to obtain an injunction and a motion to expedite the proceedings, even though track meets aren't occurring and won't be occurring anytime soon. What I thought was particularly remarkable is that they actually, the plaintiff's counsel removed to have the judge recused, recuse himself because during a telephone conference with all counsel, he asked that plaintiff's counsel refrain from continuing to refer to trans females in the case as males, which they insisted in doing throughout their pleadings and in the complaint. The plaintiffs objected that, suggesting that showed he'd already reached a decision and was biased. And the judge came down and said, this is not an act of bias. It was an act of really simple and basic decency, which he just thought was appropriate, and made it very clear he hadn't prejudged the case or anything. but it gives you a strong sense of how aggressively the plaintiff's counsel is going after these claims in this matter.
We're going to turn in a minute to the Title IX final rule, which I'm sure everyone has heard of. But before we do, some brief comments from Melissa and then Natasha.
Yeah, so I just wanted to mention, one of the things that's interesting to me about the Connecticut case is the Department of Justice filed a statement of interest to intervene in that case. And if you read what they said about Title IX and why they are supporting the cisgender athletes in that setting, it reads like the dissent in Bostock. It reads like the losing arguments. And it's hard not to draw that comparison in retrospect when you go back and look at it. And that is what the U.S., Department of Justice is defending the U.S. Department of Education's reading of Title IX, and that's what they're hanging their hat on right here. So I think one thing that I noticed about that statement of interest that I think really gets to the heart of it is they keep saying things like boys shouldn't be allowed to play girls' sports. So the crux of the matter is, are transgender girls girls? That's it. That's what we're debating in all of this, right? And the courts seem to be saying they're girls. But nobody's been that specific about it. And maybe if we get that moment, that will be our cultural clarity for this.
Natasha?
Yeah, I just wanted to remind everyone that it's a vulnerable situation to be relying on the Supreme Court and random circuit courts to enforce civil rights, and that this really all gets back to control over the federal courts, control over the legislature, which all ties back to voting. Like, this just is what makes this fall so critical, because we've got people that are trying to stack the courts and frankly have done quite a good job of stacking the courts for the next lifetime tenured federal judges. So, it makes me incredibly nervous to rely and hope, and I like these lit opinions, but they're not a guarantee, and that's not a strategic civil rights enforcement.
Yes, absolutely. So let's turn to the Title IX final rule. We were all having a pretty terrible March and April, and then May 6th, the Department of Education said, hold my beer. We are going to make it even worse. And I will just share, for those of you who have not, this is my printed copy of the final rule. And of course, we try to be a little bit green, so that's my two-sided printed copy. If I printed that on one side, I don't think I'd be able to I'd have to get a wide lens webcam. It is an incredibly complex rule. The research is fairly clear that our LGBTQIA+ students experience violence at a higher rate, that they often have fewer resources to turn to on campus and in the community. And frankly, I don't think it's surprising that that differential has been magnified during COVID-19. And it's certainly something that's on the minds of everyone on this panel and everyone out there. So the final rule claims in the preamble to be pretty agnostic on the basis of sexual orientation and gender identity. And I don't know that I buy it. It's something that is very, very complex. So I want to start by asking, what specific aspects of the final rule can you identify as falling inequitably on our LGBTQI+ students in higher ed and K-12 or on campus community members? And let's start with Shiwali for this question.
I always do this, I'm on mute. Yeah, so, as you pointed out, LGBTQI students, and especially LGBTQI students who are living at the intersections of other marginalized identities, are more vulnerable to sexual assault and other forms of sexual harassment, and yet are less likely to receive supportive responses, after they are victimized. And so these rules, which significantly undermine protections against sexual harassment in schools, and also would make it easier for religious institutions to, discriminate, which I'll talk about later, would, exacerbate these issues that, many students face, in particular LGBTQ students, and would also exacerbate the issue under reporting. And so There are quite a few provisions. I think kind of as a whole, what this rule does is to essentially make it harder for students to report by changing the notice standards around sexual harassment complaints, such that only complaints that are made, at least in higher education, to a particular subset of employees, it'd have to be a Title IX coordinator or an individual with authority to institute corrective measures. Those would be the types of reports that would be counted that would actually trigger a response that would be required under Title IX. And so, you know, with this change, there is a concern that, you know, students who might not feel comfortable turning to the dean of their school or Title IX coordinator because they don't know if they're friendly towards LGBTQ students or might not have a trusted relationship with them, may be deterred from reporting. There are also procedures that once a school, and I'm so sorry, I have multiple devices, but once a school is required to conduct an investigation, that the procedures that they would have to use, especially in higher ed institutions, could be hostile towards survivors by requiring processes like direct live cross-examination that could be re-traumatizing, but would also set up inequities that would particularly harm students who already have a more difficult time, face more burdens when it comes to reporting or when it comes to receiving supportive responses from their schools. And so, you know, we have concerns about the presumption of non-responsibility, for example, that would require schools to start an investigation with the presumption that no sexual harassment occurred. That is, essentially, schools would be effectively required to presume that students who report are the ones who are not being truthful. And, you know, this will fall disproportionately on students of color, in particular, Black girls who oftentimes are disbelieved when they report or are punished, LGBTQ students and students with disabilities who already face more skepticism and punishment often when they report and experience sexual harassment. There's also a retaliation provision, which is new, that allows schools to now discipline students for making materially false statements in bad faith without it being considered retaliation, as long as the decision of discipline is not solely based on the outcome of the investigation. And there are concerns that with the threat of discipline, if a student determines an accusation is false, that will deter many survivors from coming forward and from initiating an investigation, especially students who are less likely to be believed when they come forward in the first place. And then I know we're limited in time, so I just wanted to also briefly talk about the religious exemptions. Under the previous Title IX rule, religious schools were allowed to claim a religious exemption from particular Title IX requirements by notifying the Department of Education's Office for Civil Rights in writing, and also identifying which provisions of the rule conflict with their religious beliefs. Historically, this has been used to exclude women from certain programs to become like ministers, for example. It would be used to justify discriminating against students who were unmarried and engaged in premarital sex. And then more recently been used to request exemptions to discriminate against LGBTQ students. Since 2013, around the time the Department of Education started making pronouncements that it recognized discrimination against transgender students, for example, as being discriminatory. We saw more requests coming in from religious institutions requesting exemptions under Title IX regarding their treatment of LGBTQ students. So under this new rule, the Department of Ed has assured schools that they no longer have to provide any advance notice of their intent to discriminate, their intent to claim a religious exemption from Title IX, which really removes any notice to students and their families that the school that they're attending or planning to attend would claim a religious exemption against them. And this will be especially harmful for women and girls, for LGBTQ students, because as I said, a lot of schools more recently were claiming exemptions in order to discriminate under Title IX against LGBTQ students, to pregnant parenting students, and students who access or attempt to access birth control or abortion.
Thanks, Shiwali. Paige, according to the leaked copy of your timesheets that I have seen, you have developed 6,184 Title IX policies since May 19th. And I wonder if you can build on what some of Shiwali said as we sort of now start to dive into unpacking the Title IX final rule, and then maybe how you're addressing this in the policies that you're writing. Oh, I'm sorry, 6,184. You wrote 2 policies while we were on this session.
Thank you. I was gonna clarify. I appreciate the recognition there, but yes, we have, like many of my colleagues on this panel, have been doing a lot of these Title IX policies. I understand firsthand how frustrating and overwhelming and challenging it is to take these, 2,000-page regulations and turn it into something that makes sense to our community. And I think that's even more challenging for our community members of color and sexual orientation and gender identity status students. So how have we been navigating that as a practical matter? Well, the best we can, right? And so a couple of really of the, I guess the 2 main challenges that we focused on are, first, again, taking those 2,000 pages and making it into something that folks can actually navigate so that they don't feel as intimidated, notwithstanding the challenging rhetoric and sort of the intimidation of just opening up a policy and seeing that, I think our latest was, 40 pages. And so figuring out ways to break these policies into, manageable chunks, creating links, creating resources and diagrams and flowcharts, and most importantly of all, making statements very early on our websites and right up front in our policies that affirm our institution's values with respect to how we're going to interpret these for all students, and so that they represent all community members. And I should say students and faculty. Of course, these apply to our employees. And we found that that's really important. We've been receiving lots of questions of, can we still say that that our policy applies irrespective of sexual orientation or gender identity status? And the answer, obviously, yes. The regulations in many cases are constraining, but they're also the floor and don't have to set our values. And so I think for many folks, that statement of non-discrimination in the past has been sort of a compliance checkbox. And now it's the introduction to something that, might actually be really, really important. I just want to echo some points that Shiwali made, that women of color, and in particular Black women, are tremendously overrepresented in crimes of violence and sexual violence. And so it's more important now than ever, really, that we make sure that, despite all of the really good work that we're doing on your policies, and I know you're calling your great outside counsel and there's great in-house counsel working on it. It doesn't matter how beautiful and polished that policy is. It doesn't matter how great your statement is and that you've made sure to give examples and hypos and definitions that sort of encompass all sort of lived experiences in this space. Really now more than ever is the time to really focus on those support and resources, and I know we're in, for many schools, the virtual environment, and we're social distancing, and it makes a lot of that prevention and awareness training programming difficult to do. But it's so important that we're out there in the community building those relationships early and often, so that folks know that despite what the Department of Education has told us to do, these are our values, and this is how we're going to handle it. And it may seem very complicated, but at the end of the day, we're going to receive your report or your complaint. We're going to handle it fairly with respect to the rights of everybody involved. And regardless of, whatever the outcome may be under the regs, we're going to figure out how to support you and respond appropriately to it. And I think that's really the takeaway from the perspective of how are we going to allay the concerns of our community members.
And Rodney, you oversee Title IX at a gigantic public institution of higher education, mostly commuter. Many first generation has been, let's not paint too fine a picture of it, has been tremendously hit hard by COVID-19, especially during March and April, and some tremendous work by Keeney and by New York State and the city to bring us out of that situation. Tell us a little bit about what you're thinking, especially as you address inequities for our LGBTQI+ students. Oh, and mute.
Always on mute. First of all, I just want to echo a lot of the things that Paige has indicated, and we've kind of piggybacked or kind of picked up on that too, in that ensuring our CUNY community that despite having this new Title IX final rules come into play, that we are totally sensitive and totally on board with ensuring that we protect all individuals. I was bothered by the comment in the Title IX preamble that basically said, well, everybody's the same, so everybody's protected. And it's not, everybody's not the same. We know that our LGBTQ plus community suffers more greatly than others. We know that we have our domestic violence victims who are suffering under these circumstances. And so we have to look at each case individually and be very careful with how we unpack the assistance that we provide to those individuals. So we've worked very hard at CUNY in ensuring that even as we were putting together our policy, because we already had a sexual misconduct policy, and now we had to kind of introduce the Title IX final rules to that policy, we were very careful to work within the CUNY community and various units, including our University Student Senate people, to work with us so that we were ensured in what we were putting together, it was something that everybody could work with and that it could continue to support our mission statement. So it's about now getting ready to train and ensure that people understand that nothing really changes. Our same focus on ensuring that our students are protected and have all the rights that go with it. And we're very lucky to live in New York State, which has, layered a lot of those protection within the city, state, and, even our policy. And so that helps us as well. And it kind of supports the Bostic decisions and the Gavins and the Adams types of decisions. So it helps us a great deal.
Josh, I want to go right from Rodney's last statement into something that I think is a troubling issue for everybody who's on this panel. I think Kate perfectly painted the picture of how many of us felt when we were reading Bostock and when we learned of it. I think it's fair to say, I don't mean to speak for everyone on the panel, but nobody had that reaction on May 6th. We weren't thinking, oh God, thank God we lived today to see this wonderful time in May 6th, because I don't think any of us would have independently chosen that. I got a message. One person did cry, but not the same type of crying as for Bostock. And so I don't know that we would have created this. So now let's get into Bostock and its impact on the 106.45 aspect of the Title IX final rule that is hard to find a champion for among those of us who do this work. Josh?
Yeah, I mean, let me say, Joe, that, when the folks who were talking before me about the rule and about the way that it applies to people who are being discriminated against on the basis of their sexual orientation or their gender expression. I mean, the rule is full of overt discrimination on that basis, right? I mean, it says that it applies to conduct on the basis of sex, but it says that really doesn't apply to gender expression or to sexual orientation. And it defines rape as, basically heterosexual rape and sodomy, right? This sort of horrible, antiquated concept that sex between people of the same gender is something different than sex between heterosexual individuals, right? And so the rule is sort of full of these things. But it's also a rule of limited application, right? And so, people who are in the audience who have sort of studied this know that it doesn't apply to conduct that happens outside the United States, and it doesn't apply to conduct that happens outside the program or activity of campus. And so many of us have focused a lot on how to limit where this rule is going to apply, where this rule that others have talked about is going to discourage reporting, as Shiwali talked about, is going to require procedures that are re-traumatizing for victims. How can we not use this rule when we don't need to? And then Bostock comes along, right? And Bostock says that on the basis of sex means, including discrimination against people on the basis of their sexual orientation or gender expression. And that's a huge victory, but it applies in the civil context. And we have the Department of Education telling us that those aren't forms of sexual harassment necessarily under the Title IX rule that the Department of Education is going to apply to schools. And so we sort of had this weird sort of dissonance, this nuance where for a moment in time, that it is not legally allowed to make that distinction, a distinction that I think we all agree is wrong and should be changed as a normative matter, actually provides this little loophole to not use these really sort of oppressive procedures in certain allegations of sexual harassment perpetrated on the basis of gender orientation or gender expression. And I think, there's a lot packed up in there, right? Because not every institution wants to do the right thing all the time. And we do want to make sure that people are protected from harassment on that basis. But for institutions that do want to do the right thing, there is this sort of loophole where we might say, well, for certain kinds of discrimination on the basis of gender expression or sexual orientation, we can use these non-Title IX procedures in some cases. And I think right now it's really unclear what the law is on that. It's clear that for civil claims, when you want to sue a school or sue your employer, that's going to be covered under Title IX, even when it arises from gender expression or sexual orientation. But right now, there is, I think, this short window where if we don't want to apply these really oppressive Title IX procedures, there may be a loophole. And I think other people on the panel maybe disagree with me about that a little bit. And I think, the thing to, I don't think it's a normative statement about whether or not that type of discrimination should be protected. I think, the schools that Paige and Natasha and Melissa and I do work for, they want to do the right thing. They want to protect people from discrimination on those bases. But how do you do it? Do you have to use these procedures that the department says institutions have to use on the basis of sex? Because we agree that protects that conduct, even where those procedures are really oppressive, or do we have a chance to go a different way? And I think the combination of the huge win on Bostock and the rights that vindicates from a civil rights perspective versus, sort of a department that doesn't believe in those rights in the first place, forcing us to use these really oppressive procedures, it creates this sort of strange dissonance that I think we're going to be working through for the next year or so.
Scott, I love the picture that's painted by the term, oppressive procedures. And, we have a little chat for the speakers just so we're, keeping time and everything. And folks have been writing, yes, we had reason to cry for one of these and we had reason to cry for another. And then those of us who are doing the kind of work we do, we started thinking about where they connect. And I think Josh has painted that picture. And I really like the term, the oppressive procedure. Scott, your thoughts on that?
I don't know how anyone else is going to feel about what Josh says. I agree with every word of what he just said. These procedures are not anything anybody who wants to reach a right and good and fair result would want to apply or seek to apply. I think there are certain aspects of the regulations that are certainly justifiable if due process and fairness are your concerns. However, they also include or constitute essentially a series of unique rules of evidence that would not apply in any courtroom anywhere in this country. They seem calculated to keep out information that any decision maker at any place would consider to be relevant and important. So while I understand kind of the intent and desire of anyone to say, who's transgender to say, hey, I want to embrace the protections of Title IX too. I want Title IX to apply to me. I get that. But right now I agree with Josh. There is an unfortunate loophole that provides a disincentive to say, wait a minute. I don't think you want us to address it that way or to accept that point, because right now we're able to provide you an entirely different set of procedures that we really think will fairly address your concerns and address your complaints about whether it's discrimination or harassment or the like. But it's unfortunate that we have a set of rules or this disincentive to embrace these rules. I mean, and it puts, I think, transgender folks with this difficult Hobson's choice. I mean, this is not a club that I would want to be a member of right now, meaning the club that has to apply these rules to my claims of discrimination and harassment.
And Natasha, I'd ask you to build on that. And this is something we've exchanged notes on this, very early in the morning, very late at night. I know it's something you think about very deeply. And so if you can kind of touch on this, but also maybe touch on the distinction between Title IX discrimination and Title IX harassment and how those are covered here.
Sure. So are you just confessing to the whole world that I have no boundaries and ask people about Title IX at all hours of the day?
Not at all.
I'll own that. Yep.
That is true.
It's true. It's true.
It's not unwelcome, so it's fine.
So yeah, I mean, just to really further unpack this, right? So I mean, this is, I'm not a policy person, I'm a lawyer, but this is a horrible way to have a civil rights enforcement scheme, right? We have so many different standards proceeding right now. And the fact that there are loopholes really points to the fact that there's not comprehensive civil rights protections and enforcements. So the distinction here is the new, very formal Title IX regulations cover harassment on the basis of sex. And so as we've been talking about, what that term sex includes for the purposes of these regulations is open to debate right now, but it only includes harassment on the basis of sex. Discrimination is a whole separate legal category and it has always been covered by Title IX and is handled outside of this formal process under your Title IX grievance procedures that have been required since the 70s. So, what we're really seeing is as we unpack all of these regulations and all of these decisions is employers, institutions of higher education, other recipients of federal funds having to get very precise on what is discrimination. Discrimination is something that's on the basis of a protected category when the decision or action or omission is pursuant to the individual's job duties and responsibilities. So we think about discrimination as something on behalf of the institution, right? So if I engage in pay disparity, and I'm the person who implements that pay disparity, I'm acting on behalf of the institution, and I'm acting on behalf of the terms and conditions and duties of my employment, versus harassment, which is conduct that's never in the course and scope of my employment. Harassment's outside, it's slurs, it's other unwelcome behavior, but we've now parsed this distinction between discrimination and harassment, which were traditionally handled under one comprehensive policy. And so just another distinction to be aware of is, at this point, there are so many different internal definitions, policies, procedures. It's not a comprehensive enforcement scheme at any level, federally or state. And it really just, this is why you have to vote. I'll just keep saying that.
Yeah, and Paige, and then Jody, I'm going to call on you after Paige. We are also thinking about the impact of the killing of George Floyd, of course, what happened in Wisconsin this week, and what's been happening every week, and the general feelings of inequity and racial disparities that we are seeing. We are seeing disparities on the basis of sexual orientation and gender identity that were not cured by the Obergefell decision. We had a great panel with the writer of From Outlaws to In-Laws earlier this week, and our students are thinking about all these things as they come back to our campuses. You're now up to 7,933 policies. You went off screen just to write another 50. But in all seriousness, what can colleges do to try to preserve some of the equitable treatment in a world where we're dealing with the Title IX final rule and everything else? I'll ask you for your thoughts, and then for Jody to comment as well.
Yeah, this is clearly the easiest question that we're posing today on this panel today, but I'm happy to take a crack at it and then hear from all these other smart people. Look, I think it's been well said how challenging, overwhelming, burdensome, oppressive is the word of this session. That I think all those make a lot of sense for how the Title IX regulations sort of feel as we're implementing and writing policy and figuring out how to handle complaints. When you layer that on top of everything else going on, I work with an amazing partner. His name is Scott Schneider, and he's been saying this, it's like if the Title IX regulations weren't enough, it's not as if this is the easiest semester in higher education. In fact, it's probably one of the most challenging semesters ever in the history of higher education, between these new regulations and the cultural implications of them, social implications of them, COVID-19, which, for a long time, I know many of my outside counsel colleagues, we've been COVID-19 lawyers, it feels like, for the last 10 years, but really the last 6 months. And then, of course, there's this huge suite of policy work, litigation, investigations, and demands, and responding to complaints in the wake of the murder of Black men like George Floyd and others. And so it's a very challenging time. So I just thought I'd start with that and acknowledge it. It's been very interesting as someone who works as outside counsel. You think that the Title IX work would really be the bulk of the work, but really over the summer, the bulk of my practice has actually been around investigations and compliance work and climate issues around racial bias and Title VI complaints. And this is coming directly out of the George Floyd shooting. And so what are we going to do when all of these are sort of layered around the other? And what I can tell you, we've been doing these sort of broad, comprehensive reviews of schools and sort of how we sort of get to the culmination of a huge social media campaign villainizing a single university administrator as racist, or calling out the university police, or various other ways that this sort of gets expressed and the frustration is articulated. And the number one takeaway I have is that there were always signs along the way. And I think, and I know that there are many issues and items demanding your attention and your budgets and your legal counsel looking into, but we can't lose sight of, our educational missions. And I'm here to tell you that really our commitment to DE&I, to diversity, equity, and inclusion centers, the staff and the support people who run those centers, the personnel who make that possible, they're so important now more than ever before. I think dealing with all the intersection of all of these issues that this conference has done such a great job highlighting. And so I really think doing sort of that preemptive work and evaluating when students are dealing with the fallout that's inevitable as the campaign proceeds and the election happens and November gets closer, trying to think creatively about how we're going to anticipate our students' needs, what resources and how we're going to create those spaces to have these difficult conversations. And then finally, approaching all sorts of civil rights complaints, including sex discrimination and Title IX complaints, with the lens that these issues are interconnected. And I think that's a challenge that many schools deal with in terms of connecting with the community. So many students, particularly women of color, will come forward and they'll have a bevy of complaints, and it'll be one complaint that involves sort of sexual harassment, another that involves a racial component. And from the student or the employee's perspective, right, all of this is culminating into a hostile environment and affecting their ability to access education or employment. And I think an old school approach is to slice and dice and separate and dismiss complaints. I think the more appropriate, modern, and certainly the more humane approach is to think about that context. And even in those cases where our complaints aren't meeting the definition of our policy violations, we're really going beyond that and thinking about things like restorative justice and options to address harms, to meet the needs of the folks who've been impacted, and to try to path forward. And I think too often we get stuck being reactive because there's so many things demanding our time. But if we can take a moment and carve out that space to think critically about it on the front end, I think we'll be set up for better success, going forward.
Yeah, absolutely. And before I ask Jody our big RIFRA question that we've been talking about, I want to ask Shiwali to comment and add her voice as well, and maybe to specifically key in on the challenge of some of the confusing aspects of the final rule to getting to the world Paige painted just there.
Yeah, thank you so much, Paige, for saying that. I think it is such an important message to make to students and to school administrators and to families and to really everyone who cares about students that you know, there are ways that schools can still be supportive of survivors and do you know, kind of more than what the rule calls for and should be. And so I am always, you know, I'm just really excited to hear that you all are some of the folks, my co-panelists that are working with schools to ensure that's happening, and do really appreciate that. So I just wanted to kind of, you know, as Josh and Natasha and Scott were kind of talking about, you know, what's considered sex-based harassment in light of Bostock and what falls under, what type of harassment falls under 106.5 or doesn't. It kind of just made me think about how confusing this rule is, that, you know, you have a bunch of experts here who are working on implementing this rule and who are Title IX experts, and yet we have a difference of opinion on some of these provisions. And, you know, I frankly still have questions about how some of that actually does apply in practice. And, you know, I think it says a lot about the flaws of the process, you know, and of this whole process that went into developing these Title IX rules. But in some ways, it also presents opportunities for, you know, schools to identify where the gaps are, where they might be able to do more to protect students because it's not clear in the rule. And so, you know, there was one, I just wanted to kind of point out this blog post that came out on August 5th, just because it didn't go through the normal channels that should have gone through for any sort of critical guidance coming out of the federal government about the Title IX rule, where the Department of Education indicated through a blog post, they've had several come out, I think, in light of questions that have been raised on the rule, stating that for assaults or harassment that occurs before August 14th, which was the implementation date, that the rule wouldn't really apply. You know, it's a very late pronouncement by then. Again, you all would know in the audience, if we're with the schools and those working with schools, that schools have already been working on implementing these changes. And so to make this announcement not even 10 days before the rules is to go into effect is not very helpful. And it does pose a lot of questions to me, at least, when I think of what about harassment that's continuous, right, that occurred before and then goes through August 14th. But it's just an example of where there could be so to speak, a loophole, I guess, you know, ways that schools can still think about how they could protect students depending on when their harassment occurred. And so that's all I wanted to really share about that. I could go on, and I know we're in a little on time. I think we all could, about all the questions that we still have about this rule and what it means for implementation of it.
And Shiwali, you know, there was more guidance that came out on August 13th, the day before, and I didn't know whether to laugh or cry when a colleague told me that they had gotten a note from the Open Center saying, sorry, we got a lot of questions and it's a very short turnaround to turn them over. And I was like, oh, short turnaround, you don't say. I hear you. Jody, we have a great question, and this is something we have discussed. The Supreme Court giveth and the Supreme Court taketh away. A week after Bostock, we had a number of cases that dealt with some flexibility shown to certain organizations that claim a religious mission in following what are otherwise a standard to follow federal or state laws. Can you talk a little about that? I know it's something that's on everybody's mind. Oh, and you're on mute.
I just permanently do that. I gotta work on it. Sorry. So a couple cases came down recently, touched on religious freedom and other aspects. There was a case coming out of Montana involving whether or not monies could be used for private religious schools. And then there was also the Little Sisters case in Pennsylvania. And I want to sort of take a moment on that. It might seem odd to talk about insurance and the Affordable Care Act and contraception and Title IX all at the same time. But one of the questions was, can religious employers be exempted from providing insurance coverage for contraceptives? But it also looked at how religious employers can self-certify and become exempt from other laws, potentially, is what is sort of hidden within some of the language of that case that gives people concern. And there was also some questions about the administrative processes that were used to allow an exemption for the Little Sisters, who decided that they would be exempt from having to follow certain requirements of the Affordable Care Act. And so the Supreme Court upheld the authority under the Affordable Care Act to promulgate certain religious and moral exemptions. But we care under Title IX and the other topics we've been talking about because it made it much easier to make a loophole around certain laws. Here it was the Affordable Care Act, but you can now, according to this, have a simple moral objection that would allow you to avoid complying with laws. Would that allow you to avoid complying with certain non-discrimination laws? You can have a deeply held religious belief, as opposed to the types of exemptions that we have required in the past, or be a religious organization such as a church. This is a much lower standard than being a religious institution. And so there's a concern that this could pave the way for employers to use these religious deeply held beliefs or moral beliefs as a license to discriminate. If employers can do that in general, can schools also do that, whether on the employment side, or could it morph into other ways to decide not to afford protections under our other federal non-discrimination statutes? So I think it's, certainly not a law that talks specifically about Title IX or even employment and discrimination in that sense, but it is, it's nerve-wracking, to say the least, that is out there and provides this really easily met loophole. And I'm sure others can pick up where I left off there and find other reasons to be anxious and nervous about the law.
Yeah, and the Supreme Court is going to consider another case, which I think 10 years ago, the Philadelphia case, and I think 10, 20 years ago, that case would have been a 9-0 decision. And the fact that we're worried in that case, in super brief, has to deal with the sort of contracting aspect when a state doesn't require, but it says, we'll give you a contract, but you have to follow these rules. I think that would have been a super simple 9-0, and now we're worried about it. And Natasha, you had a closing thought on that.
Coming off mute like Jody, and I just want to apologize, Jody, I wasn't laughing at you. My dog decided to make an appearance and join the panel for a minute there, so I was trying to get him out of the way. So for the recording, I think that this just all goes to the tenuous nature of civil rights protection right now. And we started the panel off talking about some of the recent positive developments, but it's for those of us that are following along closely. It sometimes feels like those advancements are hanging by a sliver. And so, I think we just need to be mindful of where the law is going and legislative protection that would be useful and where the sources of that power derives from. And I apologize for my dog making an appearance.
Not at all. And that is sort of standard fare in 2020. Children, dogs, it is all welcome. Before I turn it over to Elizabeth, I just wanted to offer my thanks. 2020 has been, I think, for all of us, our most difficult year. To have great colleagues across the country, great thought leaders around the country who are willing to take my call. Who am I, just some lawyer in Albany? What a privilege. Melissa, Shiwali, Rodney, Natasha, Jody, Scott, Kate, Paige, and Josh, thank you. Thank you for committing to this work and to coming to SUNY Spectrum. Thank you for closing us out. Thank you for your great thoughts and your deep analysis. Thank you for your friendship and all the incredible work that you do. What a privilege. And I want to close out something that to send it over to Elizabeth, something that she has been working on for months to put together this incredible conference, 18 sessions, 27 hours. The fact that we did it for $25 a person, just absolutely unreal. And how much I wish we were all in person, but if we couldn't be in person, we really were able to have a great conference. To close us out, Elizabeth Brady.
Thanks, Joe. And thank you so much to all of our panelists. Thank you so much to everyone in attendance. We have had a really incredible experience. I know I've had a really incredible experience. It was a huge bummer to not be able to connect with everyone in person. But, you know, we gave ourselves a week to stomp around and pout and then got back to work once we realized that Live Spectrum wasn't going to be happening. So thank you to all of you. And we want to wish everyone the very best of luck as they go forward and, you know, throughout the academic year and all of the challenges that are to come. Thank you so much for joining us, and happy Spectrum, and have a great semester. Thank you so much.